In this episode of Estate Planning Essentials, we will explore what a Clayton election is and how and when to use it. Hey everyone, welcome to Estate Planning Essentials. I'm Kristen, Product Specialist at WealthCounsel. On this channel, we supply tips and information on document drafting and estate planning. So if you're a newcomer, please consider subscribing to the channel. And hey, at any point during the video, check out our show notes and links in the description below. Today, we'll be covering the Clayton election, where we'll get into the definition of Clayton election, as well as considerations of when to use Clayton election. So let's get started. The name Clayton election comes from a 1992 Fifth Circuit U.S. Court of Appeals case called Clayton v. Commissioner. The election is made after the death of the first spouse by an independent personal representative on a timely filed federal estate tax return, Form 706. This is typically due 9 months after the date of death, but may be extended for an additional 6 months. If extended, the personal representative would have 15 months after the decedent spouse's death to determine the best allocation of assets between the bypass and the QTIP trust. Any of the deceased spouse's assets which are not allocated to the QTIP trust are allocated to a bypass trust. By deferring the decision of how to allocate assets until the first spouse dies, the personal representative has the ability to assess the value of the total marital estate and the needs of the beneficiaries at that time. Other considerations may also come into play, including whether assets should be includable in the estate of the surviving spouse in order to benefit from a step-up in basis upon the death of the surviving spouse, or whether they should continue free of any estate tax to the next generation. Given the high estate tax exemption currently and the availability of portability as a strategy to ensure that a deceased spouse's exemption is not lost, Clayton election planning is more of a safeguard than a necessity in most cases today. For clients with estates which are likely to exceed the exemption amount, this type of planning should be considered as a way to bring the federal estate tax liability down to zero at the death of the first spouse. It's also helpful to implement this technique as an alternative to disclaimer planning, where it's clear that the surviving spouse is likely to be too distraught or not financially savvy enough to timely make a decision to disclaim assets. Thanks for checking out this video, and please make sure you like and subscribe to see more videos like it. If you'd like more information about Clayton election, you can always access that information right here. Or check out the show notes and links in the description below. See you next time.